2008, DC versus Heller. This is the first of a number of key cases that gave us and recognized our Second Amendment rights as we see it today. An individual right that protects ordinary citizens who are lawful, carrying firearms that are common for lawful purposes, including self-defense, among other expressions of the right. If you're like me, you like to listen to things that are long because it's difficult to find time to sit down and read everything. So I thought I would try reading the majority decision. That's the part that's the actual controlling law in this case. It's going to take some time. You already knew that when you clicked on this. So settle in, and I hope you enjoy 2008, Antonin Scalia, DC versus Heller. Scalia, we consider whether a District Court of Columbia prohibition on the possession of usable handguns in the home violates the Second Amendment to the Constitution. 1. The District of Columbia generally prohibits the possession of handguns. It is a crime to carry an unregistered firearm, and the registration of handguns is prohibited. Wholly apart from that prohibition, no person may carry a handgun without a license, but the Chief of Police may issue licenses for one-year periods. District of Columbia law also requires residents to keep their lawfully owned firearms, such as registered long guns, quote, unloaded and disassembled or bound by a trigger lock or similar device, end quote, unless they are located in a place of business or are being used for lawful recreational activities. Respondent Dick Heller is a D.C. Special Police Officer authorized to carry a handgun while on duty at the Federal Judicial Center. He applied for a registration certificate for a handgun that he wished to keep at home, but the district refused. He thereafter filed a lawsuit in the Federal District Court for the District of Columbia seeking, on Second Amendment grounds, to enjoin the city from enforcing the bar on the registration of handguns, the licensing requirement insofar as it prohibits the carrying of a firearm in the home without a license, and the trigger lock requirement insofar as it prohibits the use of, quote, functional firearms within the home, end quote. The district court dismissed respondent's complaint. The Court of Appeals for the District of Columbia Circuit, construing his complaint as seeking the right to render a firearm operable and carry it about his home in that condition only when necessary for self-defense, reversed. It held that the Second Amendment protects an individual right to possess firearms and that the city's total ban on handguns, as well as its requirement that firearms in the home be kept non-functional even when necessary for self-defense, violated that right. The Court of Appeals directed the district court to enter summary judgment for respondent. We granted certiorari in 2007. Number 2, we turn first to the meaning of the Second Amendment. Part A. The Second Amendment provides, quote, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed, end quote. In interpreting this text, we are guided by the principle that, quote, the Constitution was written to be understood by the voters. Its words and phrases were used in their normal and ordinary as distinguished from technical meanings, end quote. Normal meaning may of course include an idiomatic meaning, but it excludes secret or technical meanings that would not have been known to ordinary citizens in the founding generation. The two sides in this case have set out very different interpretations of the amendment. Petitioners and today's dissenting justices believe that it protects only the right to possess and carry a firearm in connection with militia service. Respondent argues that it protects an individual right to possess a firearm unconnected with service in a militia and to use that arm for traditionally lawful purposes such as self-defense within the home. The Second Amendment is naturally divided into two parts, its prefatory clause and its operative clause. The former does not limit the latter grammatically, but rather announces a purpose. The amendment could be rephrased, quote, because a well-regulated militia is necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Although this structure of the Second Amendment is unique in our Constitution, other legal documents of the founding era, particularly individual rights provisions of state constitutions, commonly included a prefatory statement of purpose. Logic demands that there be a link between the stated purpose and the command. The Second Amendment would be nonsensical if it read, quote, A well-regulated militia, being necessary to the security of a free state, the right of the people to petition for redress of grievances shall not be infringed, end quote. That requirement of logical connection may cause a prefatory clause to resolve an ambiguity in the operative clause. Parentheses, quote, the separation of church and state being an important objective, the teachings of canons shall have no place in our jurisprudence, end quote. The preface makes clear that the operative clause refers not to the canons of interpretation, but to clergymen, end parentheses. But apart from that clarifying function, a prefatory clause does not limit or expand the scope of the operative clause. Quote, it is nothing unusual in acts for the enacting part to go beyond the preamble. The remedy often extends beyond the particular act or mischief which first suggested the necessity of the law, end quote. Therefore, while we will begin our textual analysis with the operative clause, we will return to the prefatory clause to ensure that our reading of the operative clause is consistent with the announced purpose. Number 1, operative clause, sub A, quote, right of the people, end quote. The first salient feature of the operative clause is that it codifies a, quote, right of the people, end quote. The unamended Constitution and the Bill of Rights use the phrase, quote, right of the people, end quote, 2 other times in the First Amendment's Assembly and Petition Clause and in the Fourth Amendment's Search and Seizure Clause. The Ninth Amendment uses very similar terminology. All 3 of these instances unambiguously refer to individual rights, not, quote, collective, end quote, rights, or rights that may be exercised only through participation in some corporate body. 3 provisions of the Constitution refer to, quote, the people, end quote, in a context other than, quote, rights, end quote. The famous preamble, we the people, of Article 1, providing that the people will choose members of the House, and the 10th Amendment, providing that those powers not given to the federal government remain with the states or the people. Those provisions arguably refer to the people acting collectively, but they deal with exercises or reservations of powers, not rights. Nowhere else in the Constitution does a right attributed to, quote, the people, end quote, refer to anything other than an individual right. What is more, in all 6 other provisions of the Constitution that mention, quote, the people, end quote, the term unambiguously refers to all members of the political community, not an unspecified subset. As we said in United States versus Verdugo-Urquidez, another U.S. Supreme Court case from 1990, quote, the people seems to have been a term of art employed in select parts of the Constitution. Its uses suggest that the people, protected by the Fourth Amendment and by the First and Second Amendments, and to whom rights and powers are reserved in the Ninth and 10th Amendments, refers to a class of persons who are part of the national community, or who have otherwise developed sufficient connection with this country to be considered part of that community, end quote. This contrasts markedly with the phrase, quote, the militia in the prefatory clause. As we will describe below, the militia in colonial America consisted of a subset of the people, those who were male, able-bodied, and within a certain age range. Reading the Second Amendment as protecting only the right to keep and bear arms in an organized militia, therefore fits poorly with the operative clause's description of the holder of that right as the people. We start, therefore, with a strong presumption that the Second Amendment right is exercised individually and belongs to all Americans. Part B, quote, keep and bear arms. We move now from the holder of the right, the people, to the substance of the right to keep and bear arms. Before addressing the verbs keep and bear, we interpret their object, arms. The 18th century meaning is no different from the meaning today. The 1773 edition of Samuel Johnson's dictionary defined arms as, quote, weapons of offense or armor of defense, end quote. Timothy Cunningham's important 1771 legal dictionary defined arms as, quote, anything that a man wears for his defense or takes into his hands or useth in wrath to cast at or strike another, end quote. The term was applied, then as now, to weapons that were not specifically designed for military use and were not employed in a military capacity. For instance, Cunningham's legal dictionary gave as an example of usage, quote, servants and laborers shall use bows and arrows on Sundays and not bear other arms, end quote. Although one founding era thesaurus limited arms, as opposed to weapons, to, quote, instruments of offense generally made use of in war, end quote, even that source stated that all firearms constituted arms. Some have made the argument, bordering on the frivolous, that only those arms in existence in the 18th century are protected by the Second Amendment. We do not interpret constitutional rights that way. Just as the First Amendment protects modern forms of communications, and the Fourth Amendment applies to modern forms of search, the Second Amendment extends, prima facie, to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. We turn to the phrases keep arms and bear arms. Johnson defined keep as, most relevantly, quote, to retain, not to lose, and, quote, to have in custody, end quote. Webster defined it as, quote, to hold, to retain in one's power or possession, end quote. No party has apprised us of an idiomatic meaning of keep arms. Thus, the most natural reading of, quote, keep arms in the Second Amendment is to have weapons. The phrase keep arms was not prevalent in the written documents of the founding period that we have found, but there are a few examples, all of which favor viewing the right to keep arms as an individual right unconnected with militia service. William Blackstone, for example, wrote that Catholics convicted of not attending service in the Church of England suffered certain penalties, one of which was that they were not permitted to, quote, keep arms in their houses, end quote. Petitioners point to militia laws of the founding period that required militia members to keep arms in connection with militia service, and they conclude from this that the phrase keep arms has a militia-related connotation. This is rather like saying that since there are many statutes that authorize aggrieved employees to file complaints with federal agencies, the phrase file complaints has an employment-related connotation. Keep arms was simply a common way of referring to possessing arms for militiamen as well as everyone else. At the time of the founding, as now, to bear meant to carry. See Johnson, Webster, Sheridan, a complete dictionary of the English language, as well as the Oxford English Dictionary. When used with arms, however, the term has a meaning that refers to carrying for a particular purpose, confrontation. In Muscarella v. United States, a 1998 U.S. Supreme Court case, in the course of analyzing the meaning of carries a firearm in a federal criminal statute, Justice Ginsburg wrote that, quote, surely a most familiar meaning is, as the Constitution's Second Amendment indicates, wear, bear, or carry upon the person or in the clothing or in a pocket for the purpose of being armed and ready for offensive or defensive action in a case of conflict with another person. We think that Justice Ginsburg accurately captured the natural meaning of bear arms. Although the phrase implies that the carrying of the weapon is for the purpose of offensive or defensive action, it in no way connotes participation in a structured military organization. From our review of founding-era sources, we conclude that this natural meaning was also the meaning that bear arms had in the 18th century. In numerous instances, bear arms was unambiguously used to refer to the carrying of weapons outside of an organized militia. The most prominent examples are those most relevant to the Second Amendment. 9 state constitutional provisions written in the 18th century or the first 2 decades of the 19th century, which enshrined a right of citizens to, quote, bear arms in defense of themselves and the state, end quote, or, quote, bear arms in defense of himself and the state, end quote. It is clear from those formulations that bear arms did not refer only to carrying a weapon in an organized military unit. Justice James Wilson interpreted the Pennsylvania Constitution's arms-bearing right, for example, as a recognition of the natural right of defense of, quote, one's person or house, end quote, what he called, quote, law of self-preservation, end quote. That was also the interpretation of those state constitutional provisions adopted by pre-Civil War state courts. These provisions demonstrate, again, in the most analogous linguistic context, that bear arms was not limited to the carrying of arms in a militia. The phrase bear arms also had, at the time of the founding, an idiomatic meaning that was significantly different from its natural meaning to serve as a soldier, do military service, fight, or to wage war. But it unequivocally bore that idiomatic meaning only when followed by the preposition against, which was in turn followed by the target of the hostilities. That is how, for example, our Declaration of Independence at paragraph 28 used the phrase, quote, "He has constrained our fellow citizens taken captive on the high seas to bear arms against their country," end quote. Every example given by petitioners, amici, for the idiomatic meanings of bear arms from the founding period either includes the preposition against or it is not clearly idiomatic. Without the preposition bear arms, normally meant, as it continues to mean today, what Justice Ginsburg's opinion in Mascarello said. In any event, the meaning of bear arms that petitioners and Justice Stevens propose is not even the sometimes idiomatic meaning. Rather, they manufacture a hybrid definition whereby bear arms connotes the actual carrying of arms and therefore is not really an idiom, but only in the service of an organized militia. No dictionary has ever adopted that definition, and we have been apprised of no sources that indicates that it carried that meaning at the time of the founding. But it is easy to see why petitioners in the dissent are driven to the hybrid definition. Giving bearing arms its idiomatic meaning would cause the protected right to consist of the right to be a soldier or to wage war, an absurdity that no commentator has ever endorsed. Worse still, the phrase keep and bear arms would be incoherent. The word arms would have two different meanings at once: weapons as the object of the keep, and as the object of bear, one half of an idiom. It would be rather like saying he filled and kicked the bucket to mean he filled the bucket and died. Grotesque. Petitioners justify their limitation of bear arms to the military context by pointing out the unremarkable fact that it was often used in that context, the same mistake they made with respect to keep arms. It is especially unremarkable that the phrase was often used in a military context in the federal legal sources, such as records of congressional debate, that have been the focus of petitioners' inquiry. Those sources would have had little occasion to use it except in discussions about the standing army and the militia. And the phrases used primarily in those military discussions included not only bear arms, but also carry arms, possess arms, and have arms. Though no one thinks that those other phrases also had special military meanings. The common references to those fit to bear arms in congressional discussions about the militia are matched by the use of the same phrase in the few non-military federal contexts where the concept would be relevant. Other legal sources frequently used bear arms in non-military contexts. Cunningham's Legal Dictionary, cited above, gave as an example of its usage a sentence unrelated to military affairs. Quote, "Servants and laborers shall use bows and arrows on Sundays and not bear other arms," end quote. And if one looks beyond legal sources, bear arms was frequently used in non-military contexts. Justice Stevens points to a study by Amici supposedly showing that the phrase bear arms was most frequently used in the military context. Of course, as we have said, the fact that the phrase was commonly used in a particular context does not show that it was limited to that context. And in any event, we have given many sources where the phrase was used in a non-military context. Moreover, the study's collection appears to include, who knows how many times, the idiomatic phrase bear arms against, which is irrelevant. The Amici brief also dismisses examples such as bear arms for the purposes of killing game because those uses are expressly qualified. That analysis is faulty. A purposive, qualifying phrase that contradicts the word or phrase it modifies is unknown this side of the looking glass, except apparently in some courses on linguistics. If bear arms means, as we think, simply the carrying of arms, a modifier can limit the purpose of the carriage, quote, for the purpose of self-defense or to make war against the king. But if bear arms means, as the petitioners and the dissent think, the carrying of arms only for military purposes, one simply cannot add for the purposes of killing game. The right to carry arms in the militia for the purposes of killing game is worthy of the Mad Hatter. Thus, these purposive qualifying phrases positively establish that to bear arms is not limited to military use. Justice Stevens places great weight on James Madison's inclusion of a conscientious objector clause in his original draft of the Second Amendment. Quote, "But no person religiously scrupulous of bearing arms shall be compelled to render military service in person," end quote. He argues that this clause establishes that the drafters of the Second Amendment intended to bear arms to refer only to military service. It is always perilous to derive the meaning of an adopted provision from another provision deleted in the drafting process. In any case, what Justice Stevens would conclude from the deleted provision does not follow. It was not meant to exempt from military service those who objected to going to war, but had no scruples about personal gunfights. Quakers opposed the use of arms not just for militia service, but for any violent purpose whatsoever. So much so that Quaker frontiersmen were forbidden to use arms to defend their families, even though, quote, in such circumstances the temptation to seize a hunting rifle or knife in self-defense must sometimes have been almost overwhelming, end quote, according to P. Brock in his book Pacifism in the United States. Thus, the most natural interpretation of Madison's deleted text is that those opposed to carrying weapons for potential violent confrontation would not be, quote, compelled to render military service, end quote, in which such carrying would be required. Finally, Justice Stevens suggests that keep and bear arms was some term of art, presumably akin to hue and cry or cease and desist. This suggestion usefully evades the problem that there is no evidence whatsoever to support a military reading of keep arms. Justice Stevens believes that the unitary meaning of keep and bear arms is established by the Second Amendment's calling it a right, singular, rather than rights, plural. There is nothing to this. State constitutions of the founding period routinely grouped multiple related guarantees under a single, quote, right. And the First Amendment protects the right, singular, of the people peaceably to assemble and to petition the government for redress of grievances. And even if keep and bear arms were a unitary phrase, we find no evidence that it bore a military meaning. Although the phrase was not at all common, which would be unusual for a term of art, we have found instances of its use with a clearly non-military connotation. In a 1780 debate in the House of Lords, for example, Lord Richmond described an order to disarm private citizens, not militia members, as, quote, a violation of the constitutional rights of Protestant subjects to keep and bear arms for their own defense, end quote. The London Magazine, or Gentleman's Monthly Intelligencer, 1780. In response, another member of Parliament referred to, quote, the right of bearing arms for personal defense, end quote, making clear that no special military meaning for keep and bear arms was intended as part of the discussion. Part C, meaning of the operative clause. Putting all these textual elements together, we find that they guarantee the individual right to possess and carry weapons in case of confrontation. This meaning is strongly confirmed by the historical background of the Second Amendment. We look to this because it has always been widely understood that the Second Amendment, like the First and Fourth Amendment, codified a pre-existing right. The very text of the Second Amendment implicitly recognizes the pre-existence of the right and declares only that it, quote, shall not be infringed. As we said in United States v. Cruikshank, U.S. Supreme Court case 1876, quote, this is not a right granted by the Constitution, neither is it in any manner dependent upon that instrument for its existence. The Second Amendment declares that it shall not be infringed, end quote. Between the Restoration and the Glorious Revolution, the Stuart kings Charles II and James II succeeded in using select militias loyal to them to suppress political dissidents, in part by disarming their opponents. See Joyce Malcolm to Keep and Bear Arms. Hereinafter, Malcolm. Under the auspices of the 1671 Game Act, for example, Catholic James II had ordered general disarmaments of regions home to his Protestant enemies. These experiences caused Englishmen to be extremely wary of concentrated military forces run by the state and to be jealous of their arms. They accordingly obtained an assurance from William and Mary in the Declaration of Rights, which was codified as the English Bill of Rights, that Protestants would never be disarmed. Quote, that the subjects which are Protestants may have arms for their defense suitable to their condition and as allowed by law, end quote. This right has long been understood to be the precursor to our Second Amendment. It was clearly an individual right, having nothing whatever to do with service in a militia. To be sure, it was an individual right not available to the whole population, given that it was restricted to Protestants, and like all written English rights, it was held only against the Crown, not Parliament. But it was secured to them as individuals according to, quote, libertarian political principles, end quote, not as members of a fighting force. By the time of the founding, the right to have arms had become fundamental for English subjects. Blackstone, whose works we have said, quote, constituted the preeminent authority on English law for the founding generation, end quote, cited the arms provisions of the Bill of Rights as one of the fundamental rights of Englishmen. His description of it cannot possibly be thought to tie to militia or military service. It was, he said, quote, the natural right of resistance and self-preservation, end quote, and, quote, the right of having and using arms for self-preservation and defense, end quote. Other contemporary authorities concurred. Thus, the right secured in 1689 as a result of the Stuarts' abuses was by the time the founding understood to be an individual right protecting against both public and private violence. And of course, what the Stuarts had tried to do to their political enemies, George III had tried to do to the colonists. In the tumultuous decades of the 1760s and 1770s, the Crown began to disarm the inhabitants of the most rebellious areas. That provoked polemical reactions by Americans invoking their rights as Englishmen to keep arms. A New York article of April 1769 said that, quote, it is a natural right which the people have reserved themselves, confirmed by the Bill of Rights, to keep arms for their own defense. End quote. They understood the right to enable individuals to defend themselves. As the most important early American edition of Blackstone's commentaries made clear in the notes to the description of the arms right, Americans understood the right of self-preservation as permitting a citizen to, quote, repel force by force, end quote, when the intervention of society in his behalf may be too late to prevent an injury. There seems to us no doubt, on the basis of both text and history, that the Second Amendment conferred an individual right to keep and bear arms. Of course, the right was not unlimited, just as the First Amendment's right of free speech was not. Thus, we do not read the Second Amendment to protect the right of citizens to carry arms for any sort of confrontation, just as we do not read the First Amendment to protect the right of citizens to speak for any purpose. Before turning limitations upon the individual right, however, we must determine whether the Prefatory Clause of the Second Amendment comports with our interpretation of the Operative Clause. Part 2, Prefatory Clause. The Prefatory Clause reads, a well-regulated militia, being necessary to the security of a free state. Part A, a well-regulated militia. In United States v. Miller, Supreme Court, 1939, we explained that, quote, the militia comprised all males physically capable of acting in concert for the common defense, end quote. That definition comports with founding-era sources, such as Webster, quote, the militia of a country are the able-bodied men organized into companies, regiments, and brigades, and required by law to attend military exercises on certain days only, but at other times left to pursue their usual occupations, end quote. The Federalist, number 46, quote, near 500,000 of citizens with arms in their hands, end quote. The Portable Thomas Jefferson, quote, the militia of the state, that is to say, of every man in it able to bear arms, end quote. Petitioners take a seemingly narrower view of the militia, stating that, quote, militias are the state and congressionally regulated military forces described in the militia clauses, end quote. Although we agree with petitioners' interpretive assumptions that militia means the same thing in Article 1 and the Second Amendment, we believe that petitioners identify the wrong thing, namely the organized militia. Unlike armies and navies, which Congress is given the power to create, the militia is assumed by Article 1 already to be in existence. Congress is given the power to provide for calling forth the militia, and the power not to create, but to organize, and not to organize a militia, which is what one would expect if the militia were to be a federal creation, but to organize the militia, connoting a body already in existence. This is fully consistent with the ordinary definition of the militia as all able-bodied men. From that pool, Congress has plenary power to organize the units that will make up an effective fighting force. That is what Congress did in the first Militia Act, which specified that, quote, each and every free able-bodied white male citizen of the respective states resident therein, who is or shall be of age of 18 years and under age 45 years, except as is hereinafter accepted, shall severally and respectively be enrolled in the militia. To be sure, Congress need not conscript every able-bodied man into the militia, because nothing in Article 1 suggests that in exercising its power to organize, discipline, and arm the militia, Congress must focus upon upon the entire body. Although the militia consists of all able-bodied men, the federally organized militia may consist of a subset of them. Finally, the adjective, quote, well-regulated, implies nothing more than the imposition of proper discipline and training. See Johnson, regulate, to adjust to rule or method. See Virginia Declaration of Rights, and Thorpe, referring to, quote, a well-regulated militia composed of the body of the people trained to arms, end quote. Part B, security of a free state, end quote. The phrase security of a free state meant security of a free polity, not security of each of the several states, as the dissent below argued. Joseph Story wrote in his treatise on the Constitution that, quote, the word state is used in various senses, and in its most enlarged sense, it means the people composing a particular nation or community, end quote. It is true that the term state elsewhere in the Constitution refers to individual states, but the phrase security of a free state and close variations seem to have been terms of art in the 18th century political discourse, meaning a free country or free polity. Moreover, the other instances of state in the Constitution are typically accompanied by modifiers, making clear that the reference is to the several states, such as each state, several states, any state, that state, particular states, one state, no state. And the presence of the term foreign state in Article 1 and Article 3 shows that the word state did not have a single meaning in the Constitution. There are many reasons why the militia was thought to be, quote, necessary to the security of a free state, end quote. First, of course, it is useful in repelling invasions and suppressing insurrections. Second, it renders large standing armies unnecessary, an argument that Alexander Hamilton made in favor of federal control over the militia. Third, when the able-bodied men of a nation are trained in arms and organized, they are better able to resist tyranny. Number 3, relationship between the Prefatory Clause and Operative Clause. We reach the question then, does the preface fit with an operative clause that creates an individual right to keep and bear arms? It fits perfectly, once one knows the history that the founding generation knew and that we have described above. That history showed that the way tyrants had eliminated a militia consisting of all able-bodied men was not by banning the militia, but simply by taking away the people's arms, enabling a select militia or standing army to suppress political opponents. This is what had occurred in England that prompted codification of the right to have arms in the English Bill of Rights. The debate with respect to the right to keep and bear arms, as other guarantees in the Bill of Rights, was not over whether it was desirable, all agreed that it was, but over whether it was needed to be codified in the Constitution. During the 1788 ratification debates, the fear that the federal government would disarm the people in order to impose rule through a standing army or select militia was pervasive in anti-federalist rhetoric. John Simile, for example, worried not only that Congress's, quote, command of the militia, end quote, could be used to create a select militia or have no militia at all, but also as a separate concern that when a select militia is formed, the people in general may be disarmed. Federalists responded that because Congress was given no power to abridge the ancient right of individuals to keep and bear arms, such a force could never oppress the people. It was understood across the political spectrum that the right helped to secure the ideal of a citizen militia, which might be necessary to oppose an oppressive military force if the constitutional order broke down. It is therefore entirely sensible that the Second Amendment's Prefatory Clause announces the purpose for which the right was codified, to prevent elimination of the militia. The Prefatory Clause does not suggest that preserving the militia was the only reason Americans valued the ancient right. Most undoubtedly thought it even more important for self-defense and hunting. But the threat that the new federal government would destroy the citizens' militia by taking away their arms was the reason that right, unlike some other English rights, was codified in a written constitution. Justice Breyer's assertion that individual self-defense is merely a, quote, subsidiary interest of the right to keep and bear arms is profoundly mistaken. He bases that assertion solely upon the prologue that can only show that self-defense has little to do with the right's codification. It was the central component of the right itself. Besides ignoring the historical reality that the Second Amendment was not intended to lay down a novel principle, but rather codified a right inherited from our English ancestors, petitioners' interpretation does not even achieve the narrower purpose that prompted codification of the right. If, as they believe, the Second Amendment right is no more than the right to keep and use weapons as a member of an organized militia, if that is, the organized militia is the sole institutional beneficiary of the Second Amendment's guarantee, it does not assure the existence of a citizen's militia as a safeguard against tyranny. For Congress retains plenary authority to organize the militia, which must include the authority to say who will belong to the organized force. That is why the first Militia Act's requirement that only whites enroll caused states to amend their militia laws to exclude free blacks. Thus, if petitioners are correct, the Second Amendment protects citizens' rights to use a gun in an organization from which Congress has plenary authority to exclude them. It guarantees a select militia of the sort the Stuart Kings found useful, but not the people's militia. That was the concern of the founding generation. Part B. Our interpretation is confirmed by analogous arms-bearing rights in state constitutions that preceded and immediately followed adoption of the Second Amendment. 4 states adopted analogs to the federal Second Amendment in the period between independence and the ratification of the Bill of Rights. 2 of them, Pennsylvania and Vermont, clearly adopted individual rights unconnected to militia service. Pennsylvania's Declaration of Rights of 1776 said, quote, that the people have a right to bear arms for the defense of themselves and the state, end quote. In 1777, Vermont adopted the identical provision, except for inconsequential differences in punctuation and capitalization. North Carolina codified a right to bear arms in 1776, quote, that the people have a right to bear arms for the defense of the state. This could plausibly be read to support only a right to bear arms in a militia, but that is a peculiar way to make the point in a constitution that elsewhere repeatedly mentions the militia explicitly. Many colonial statutes required individual arms bearing for public safety reasons, such as the 1770 Georgia law that, quote, for the security and the defense of this province from internal dangers and insurrections, end quote, required those men who qualify for militia duty individually to, quote, carry firearms to places of public worship. End quote. That broad public safety understanding was the connotation given to the North Carolina right by the state Supreme Court. The 1780 Massachusetts Constitution presented another variation on the theme, quote, the people have a right to keep and bear arms for the common defense, end quote. Once again, if one gives narrow meaning to the phrase, quote, common defense, this can be thought to limit the right to the bearing of arms in a state-organized military force. But once again, the state's highest court thought otherwise. Writing for the court in the 1825 libel case, Chief Justice Parker wrote, quote, the liberty of the press was to be unrestrained, but he who used it was to be responsible in cases of its abuse. Like the right to firearms, which does not protect him who uses them for annoyance or destruction, end quote. The analogy makes no sense if firearms could not be used for any individual purpose at all. We therefore believe that most likely reading of all 4 of these pre-Second Amendment state constitutional provisions is that they secured an individual right to bear arms for defensive purposes. Other states did not include rights to bear arms in their pre-1789 constitutions, although in Virginia a Second Amendment analog was proposed unsuccessfully by Thomas Jefferson. It read, quote, no free man shall ever be debarred the use of arms within his own lands or tenements, end quote. Between 1789 and 1820, 9 states adopted Second Amendment analogs. 4 of them, Kentucky, Ohio, Indiana, and Missouri, referred to the right of the people to, quote, bear arms in defense of themselves and the state, end quote. Another 3 states, Mississippi, Connecticut, and Alabama, used the even more individualistic phrasing that each citizen has the, quote, right to bear arms in defense of himself and the state, end quote. Finally, 2 states, Tennessee and Maine, used the, quote, common defense, end quote, language of Massachusetts. That of the 9 state constitutional protections for the right to bear arms enacted immediately after 1789, at least 7 unequivocally protected an individual citizen's right to self-defense is strong evidence that that is how the founding generation conceived of the right. And with one possible exception that we discuss, Part 2, Section D, Sub 2, 19th century courts and commentators interpreted these state constitutional provisions to protect an individual right to use arms for self-defense. The historical narrative that petitioners must endorse would thus treat the federal Second Amendment as an odd outlier, protecting a right unknown in state constitutions or at English common law based on little more than an over-reading of the Prefatory Clause. Part C. Justice Stevens relies on the drafting history of the Second Amendment, the various proposals in the state conventions, and the debates in Congress. It is dubious to rely on such history to interpret a text that was widely understood to codify a pre-existing right, rather than to fashion a new one. But even assuming that this legislative history is relevant, Justice Stevens flatly misreads the historical record. It is true, as Justice Stevens says, that there was concern that the federal government would abolish the institution of the state militia. That concern found expression, however, not in the various Second Amendment precursors proposed in the state conventions, but in a separate structural provisions that would have given the states concurrent and seemingly non-preemptible authority to organize, discipline, and arm the militia when the federal government failed to do so. The Second Amendment precursors, by contrast, referred to the individual English right already codified in 2 and probably 4 state constitutions. The Federalist-dominated First Congress chose to reject virtually all major structural revisions favored by the Anti-Federalists, including the proposed militia amendments. Rather, it adopted primarily the popular and uncontroversial, though in the Federalist view, unnecessary, individual rights amendments. The Second Amendment right, protecting only individuals' liberty to keep and carry arms, did nothing to assuage anti-Federalist concerns about federal control of the militia. Justice Stevens thinks it's significant that the Virginia, New York, and North Carolina Second Amendment proposals were embedded within a group of principles that are distinctly military in meaning, such as statements about the danger of standing armies. But so was the highly influential minority proposal in Pennsylvania, yet that proposal, with its reference to hunting, plainly referred to an individual right. Other than that erroneous point, Justice Stevens has brought forward absolutely no evidence that those proposals conferred only a right to carry arms in a militia. By contrast, New Hampshire's proposal, the Pennsylvania minorities proposal, and Samuel Adams' proposal in Massachusetts unequivocally referred to individual rights, as did 2 state constitutional provisions at the time. Justice Stevens' view thus relies on the proposition, unsupported by any evidence, that different people of the founding period had vastly different conceptions of the right to keep and bear arms. That simply does not comport with our long-standing view that the Bill of Rights codified venerable, widely understood liberties. Part D. We now address how the Second Amendment was interpreted from immediately after its ratification through the end of the 19th century. Before proceeding, however, we take issue with Justice Stevens' equating of these sources with post-enactment legislative history, a comparison that betrays a fundamental misunderstanding of a court's interpretive task. Quote, legislative history, end quote, of course refers to the pre-enactment statements of those who drafted or voted for a law. It is considered persuasive by some, not because they reflect the general understanding of the disputed terms, but because the legislators who heard or read those statements presumably voted with that understanding. Post-enactment legislative history, a deprecatory contradiction in terms, refers to statements of those who drafted or voted for the law that are made after its enactment, and hence could have had no effect on the congressional vote. It most certainly does not refer to the examination of a variety of legal and other sources to determine the public understanding of a legal text in the period after its enactment or ratification. That sort of inquiry is a critical tool of constitutional interpretation. As we will show, virtually all interpreters of the Second Amendment in the century after its enactment interpreted the amendment as we do. Number 1, Post-Ratification Commentary. 3 important founding-era legal scholars interpreted the Second Amendment in published writings. All 3 understood it to protect an individual right unconnected from militia service. St. George Tucker's version of Blackstone's commentaries, as we explained above, conceived of the Blackstonian arms right as necessary for self-defense. He equated that right, absent the religious class-based restrictions, with the Second Amendment. In Note D, entitled, quote, View of the Constitution of the United States, end quote, Tucker elaborated on the Second Amendment. Quote, this may be considered as the true palladium of liberty. The right to self-defense is the first law of nature. In most governments, it has been the study of rulers to confine the right within the narrowest limits possible. Wherever standing armies are kept, and the right of the people to keep and bear arms is, under any color or pretext whatsoever, prohibited, liberty, if not already annihilated, is on the brink of destruction. He believed that the English game laws had abridged the right of prohibiting keeping a gun or other engine for the destruction of game. He later grouped the right with some of the individual rights included in the First Amendment and said that if, quote, a law passed by Congress prohibiting any of those rights, it would be the province of the judiciary to pronounce whether any such act were constitutional or not, and if not, to acquit the accused. It is unlikely that Tucker was referring to a person being accused of violating a law making it a crime to bear arms in a state militia. In 1825, William Rawle, a prominent lawyer who had been a member of the Pennsylvania Assembly that ratified the Bill of Rights, published an influential treatise which analyzed the Second Amendment as follows. Quote, the first principle is a declaration that a well-regulated militia is necessary to the security of a free state, a proposition from which few will dissent. The corollary from the first position is that the right of the people to keep and bear arms shall not be infringed. The prohibition is general. No clause in the Constitution could by any rule of construction be conceived to give to Congress a power to disarm the people. Such a flagitious attempt could only be made under some general pretense by a state legislature. But in any blind pursuit of inordinate power, either should attempt it, this amendment may be appealed to as a restraint on both. End quote. Like Tucker, Rawle regarded the English game laws as violating the right codified in the Second Amendment. Rawle clearly differentiated between the people's right to bear arms and their service in a militia. Quote, in a people permitted and accustomed to bear arms, we have the rudiments of a militia, which properly consists of armed citizens divided into military bands and instructed, at least in part, in the use of arms for the purposes of war, end quote. Rawle further said that the Second Amendment right ought not, quote, be abused to the disturbance of the public peace, end quote, such as by assembling with other armed individuals, quote, for an unlawful purpose. Statements that made no sense if the right does not extend to any individual purpose. Joseph Story published his famous commentaries on the Constitution of the United States in 1833. Justice Stevens suggests that, quote, there is not so much as a whisper, end quote, in Story's explanation of the Second Amendment that favors the individual rights view. That is wrong. Story explained that the English Bill of Rights had also included a right to bear arms, a right that, as we have discussed, had nothing to do with militia service. He then equated the English right with the Second Amendment. Quote, Section 1891, a similar provision to the Second Amendment in favor of the Protestants, for to them it is confined, is to be found in the Bill of Rights of 1688, it being declared that the subjects which are Protestants may have arms for their defense suitable to their condition and allowed by law, but under various pretenses, the effect of this provision has been greatly narrowed, and it is, at present in England, more nominal than real as a defensive privilege. This comparison to the Declaration of Right would not make sense if the Second Amendment right was the right to use a gun in a militia, which was plainly not what the English right protected. As the Tennessee Supreme Court recognized 38 years after Story wrote his commentaries, quote, the passage from Story shows clearly that this right was intended and was guaranteed to, and to be exercised and enjoyed by the citizen as such, and not by him as a soldier or in defense solely of his political rights, end quote. Story's commentaries also cite as support Tucker and Rawle, both of whom clearly viewed the right as unconnected to militia service. In addition, in a shorter 1840 work, Story wrote, quote, one of the ordinary modes by which tyrants accomplish their purposes without resistance is by disarming the people and making it an offense to keep arms, and by substituting a regular army in the stead of a resort to the militia, end quote. Anti-slavery advocates routinely invoked the right to bear arms for self-defense. Joel Tiffany, for example, citing Blackstone's description of the right, wrote that, quote, the right to keep and bear arms also implies the right to use them if necessary in self-defense. Without this right to use, the guarantee would have hardly been worth the paper it consumed, end quote. A treatise on the unconstitutionality of slavery. In his famous Senate speech about the 1856 Bleeding Kansas conflict, Charles Sumner proclaimed, quote, the rifle has ever been the companion of the pioneer and, under God, his tutelary protector against the red man and the beast of the forest. Never was this efficient weapon more needed in just self-defense, then now in Kansas, and at least one article in our national constitution must be blotted out before the complete right to it can be in any way be impeached. And yet such is the madness of our hour that, in defiance of the solemn guarantee embodied in the amendments to the Constitution, that the right of the people to keep and bear arms shall not be infringed, the people of Kansas have been arraigned for keeping and bearing them, and the senator from South Carolina has had the face to say openly on this floor that they should be disarmed. Of course, that the fanatics of slavery, his allies, and the constituents may meet no impediment." End quote. We have found only one early 19th century commentator who clearly conditioned the right to keep and bear arms upon service in the militia, and he recognized that the prevailing views were to the contrary. Quote, "The provision of the Constitution declaring the right of the people to keep and bear arms was probably intended to apply to the right of the people to bear arms for such militia-related purposes only, and not to prevent Congress or legislatures of different states from enacting laws to prevent the citizens from always going armed. A different construction, however, has been given to it." End quote. B. Oliver, The Rights of an American Citizen, 1832. Number 2. Pre-Civil War case law. The 19th century cases that interpreted the Second Amendment universally support an individual right unconnected to militia service. In Houston v. Moore, 1820, this court held that states have concurrent power over the militia, at least where not preempted by Congress, agreeing in dissent that states could, quote, "organize, discipline, and arm," end quote, the militia in the absence of conflicting federal regulation. Justice Story said that the Second Amendment, quote, "may not perhaps be thought to have any important bearing on this point. If it have, it confirms and illustrates rather than impugns the reasoning already suggested," end quote. Of course, if the amendment simply, quote, "protected the right of the people of each of the several states to maintain a well-regulated militia," citing Stevens in the dissent, it would have enormous and obvious bearing on the point. But the court and Story derived the state's power over the militia from the non-exclusive nature of the federal power, not from the Second Amendment, whose preamble merely confirms and illustrates the importance of the militia. Even clearer was Justice Baldwin. In the famous fugitive slave case of Johnson versus Tompkins from Pennsylvania in 1833, Baldwin, sitting as a circuit judge, cited both the Second Amendment and the Pennsylvania analog for his conclusion that a citizen has a, quote, "right to carry arms in defense of his property or person, and to use them if either were assailed with such force, numbers, or violence as made it necessary for the protection or safety of either." End quote. Many early 19th century state cases indicated that the Second Amendment right to bear arms was an individual right unconnected to militia service, though subject to certain restrictions. A Virginia case in 1824 holding that the Constitution did not extend to free blacks explained that numerous restrictions imposed on blacks in our statute book, many of which are inconsistent with the letter and spirit of the Constitution, both of this state and of the United States as respects the free rights, demonstrate that here, those instruments have not been considered to extend equally to both classes of our population. We will only instance the restriction upon the migration of free blacks into this state and upon their right to bear arms, end quote. The claim was obviously not that blacks were prevented from carrying guns in the militia. An 1829 decision by the Supreme Court of Michigan said, quote, "The Constitution of the United States also grants to the citizen the right to keep and bear arms, but the grant of this privilege cannot be construed into the right to him who keeps a gun to destroy his neighbor. No rights are intended to be granted by the Constitution for an unlawful or unjustifiable purpose," end quote. United States versus Sheldon. It is not possible to read this as discussing anything other than an individual right unconnected to militia service. If it did have to do with militia service, the limitation upon it would not be any, quote, "unlawful or unjustifiable purpose," end quote, by any non-military purpose whatsoever. In Nunn versus State, 1846 Georgia, the Georgia Supreme Court construed the Second Amendment as protecting the, quote, "natural right of self-defense," end quote, and therefore struck down a ban on carrying pistols openly. Its opinion perfectly captured the way in which the operative clause of the Second Amendment furthers the purpose announced in the Prefatory clause in continuity with the English right. Quote, "The right of the whole people, old and young, men and women, boys, and not militia only, to keep and bear arms of every description, and not such merely as are used by the militia, shall not be infringed, curtailed, or broken in upon in the smallest degree, and all this for the important end to be obtained, the rearing up and qualifying a well-regulated militia so vitally necessary to the security of a free state. Our opinion is that any law, state or federal, is repugnant to the Constitution and void which contravenes this right, originally belonging to our forefathers, trampled underfoot by Charles I and his two wicked sons and successors, re-established by the Revolution of 1688, conveyed to this land of liberty by the colonists, and finally incorporated conspicuously in our own Magna Carta." End quote. Likewise, in State v. Chandler, Louisiana, 1850, the Louisiana Supreme Court held that citizens had a right to carry arms openly. This is the right guaranteed by the Constitution of the United States, and which is calculated to incite men to a manly and noble defense of themselves, if necessary, and of their country, without any tendency to secret advantages and unmanly assassinations. End quote. Those who believe that the Second Amendment preserves only a militia-centered right place great reliance on the Tennessee Supreme Court's 1840 decision in Imet v. State, Tennessee. The case does not stand for that broad proposition. In fact, the case does not mention the word militia at all, except in its quoting of the Second Amendment. Imet held that the state constitutional guarantee of the right to bear arms did not prohibit the banning of concealed weapons. The opinion first recognized that both the state right and the federal right were descendants of the 1689 English right, but, erroneously and contrary to virtually all other authorities, read that right to refer only to the protection of the public liberty and, quote, keeping in awe those in power, end quote. The court then adopted a sort of middle position whereby citizens were permitted to carry arms openly, unconnected with any service in formal militia, but were given the right to use them only for the military purpose of banding together to oppose tyranny. This odd reading of the right is, to be sure, not the one we adopt, but it is not the petitioner's reading either. More importantly, 7 years earlier, the Tennessee Supreme Court had treated the state constitutional provisions as conferring a right of, quote, all the free citizens of the state to keep and bear arms for their defense, end quote. And 21 years later, the court held that keep portion of the state constitutional right included the right to personal self-defense. Quote, the right to keep arms involves necessarily the right to keep such arms for all ordinary purposes and in all the ordinary modes usual in the country, and to which arms are adapted, limited by the duties of a good citizen in times of peace. End quote. Number 3, post-Civil War litigation. In the aftermath of the Civil War, there was an outpouring of discussion of the Second Amendment in Congress and in public discourse as people debated whether and how to secure constitutional rights for newly freed slaves. Since those discussions took place 75 years after the ratification of the Second Amendment, they do not provide as much insight into its original meaning as earlier sources. Yet, those born and educated in the early 19th century faced a widespread effort to limit arms ownership by large numbers of citizens. Their understanding of the origins and continuing significance of the amendment is instructive. Blacks were routinely disarmed by Southern states after the Civil War. Those who opposed these injustices frequently stated that they infringed blacks' constitutional right to keep and bear arms. Needless to say, the claim was not that blacks were being prohibited from carrying arms in an organized state militia. A report of the Commission of the Freedmen's Bureau in 1866 stated plainly, quote, the civil law of Kentucky prohibits the colored man from bearing arms. Their arms are taken from them by the civil authorities. Thus, the right of the people to keep and bear arms as provided in the Constitution is infringed, end quote. A joint congressional report decried, quote, in some parts of South Carolina, armed parties are, without proper authority, engaged in seizing all firearms found in hands of the freemen. Such conduct is in clear and direct violation of their personal rights as guaranteed by the Constitution of the United States, which declares that the right of the people to keep and bear arms shall not be infringed. The freedmen of South Carolina have shown by their peaceful and orderly conduct that they can be safely trusted with firearms, and they need them to kill game for subsistence and to protect their crops from destruction by birds and animals, End quote. The view expressed in these statements was widely reported and was apparently widely held. For example, an editorial in the Loyal Georgian on February 3, 1866, assured blacks that, quote, all men, without distinction of color, have the right to keep and bear arms to defend their homes, families, or themselves, end quote. Congress enacted the Freedmen's Bureau Act of July 16, 1866. Section 14 stated, quote, the right to have full and equal benefit of all laws and proceedings concerning personal liberty, personal security, the acquisition, enjoyment, and disposition of estate, real and personal, including the constitutional right to bear arms, shall be secured to and enjoyed by all the citizens, without respect to race or color or previous condition of slavery. End quote. The understanding that the Second Amendment gave freed blacks the right to keep and bear arms was reflected in congressional discussion of the bill, with even an opponent of it saying that the founding generation, quote, were for every man bearing his arms about him and keeping them in his house, his castle, for his own defense, end quote. Senator Davis, 1866. Similar discussion attended the passage of the Civil Rights Act of 1871 and the 14th Amendment. For example, Representative Butler said of the act, quote, Section 8 is intended to enforce the well-known constitutional provision guaranteeing the right of the citizen to keep and bear arms, and provides that whoever shall take away by force or violence, or by threats and intimidation, the arms and weapons which any person may have for his defense, shall be deemed guilty of larceny of the same, end quote. 1871 congressional discussion. Senator Pomeroy described as one of three, quote, indispensable safeguards of liberty under the Constitution a man's right to bear arms for the defense of himself and family and his homestead, end quote. Representative Nye thought the 14th Amendment unnecessary because, quote, as citizens of the United States, blacks have equal right to protection and to keep and bear arms for self-defense, end quote. It was plainly the understanding in post-Civil War Congress that the Second Amendment protected an individual right to use arms for self-defense. Number 4, post-Civil War commentators. Every late 19th century legal scholar that we have read interpreted the Second Amendment to secure an individual right unconnected with militia service. The most famous was the judge and professor Thomas Cooley, who wrote a massively popular 1868 treatise on constitutional limitations. Concerning the Second Amendment, it said, quote, among the other defenses to personal liberty should be mentioned the right of the people to keep and bear arms. The alternative to a standing army is a, quote, well-regulated militia, but this cannot exist unless the people are trained to bearing arms. How far it is in the power of the legislature to regulate this right, we shall not undertake to say, as happily there has never been very little occasion to discuss that subject by the courts, end quote. That Cooley understood the right not as connected to militia service, but as securing the militia by ensuring a populace familiar with arms, is made even clearer in his 1880 work, General Principles of Constitutional Law. The Second Amendment, he said, quote, was adopted with some modification and enlargement from the English Bill of Rights of 1688, where it stood as a protest against arbitrary action of the overturned dynasty in disarming the people. End quote. In a section entitled The Right in General, he continued, quote, it might be supposed from the phraseology of this provision that the right to keep and bear arms was only guaranteed to the militia, but this would be an interpretation not warranted by the intent. The militia, as has been elsewhere explained, consists of those persons who, under the law, are liable to the performance of military duty and are officered and enrolled for the service when called upon. But the law may make provision for the enrollment of all who are fit to perform military duty, or of a small number only, or it may wholly omit to make any provision at all. And if the right were limited to those enrolled, the purpose of this guarantee might be defeated altogether by the action or neglect to act of the government it was meant to hold in check. The meaning of the provision undoubtedly is that the people, from whom the militia must be taken, shall have the right to keep and bear arms, and they need no permission or regulation of law for the purpose. But this enables government to have a well-regulated militia, for to bear arms implies something more than the mere keeping. It implies the learning to handle and use them in a way that makes those who keep them ready for their efficient use. In other words, it implies the right to meet for voluntary discipline in arms, observing in doing so the laws of public order," end quote. All other post-Civil War 19th century sources we have found concurred with Cooley. One example from each decade will convey the general flavor. Quote, "The purpose of the Second Amendment is to secure a well-armed militia, but a militia would be useless unless the citizens were enabled to exercise themselves in the use of warlike weapons. To preserve this privilege and to secure to the people the ability to oppose themselves in military force against the usurpations of government, as well as against enemies from without, that government is forbidden by any law or proceeding to invade or destroy the right to keep and bear arms. The clause is analogous to the one securing the freedom of speech and of the press. Freedom, not license, is secured. The fair use, not the libelous abuse, is protected," end quote. Pomeroy, An Introduction to Constitutional Law of the United States, 1868. Quote, "As the Constitution of the United States and the Constitutions of the several states, in terms more or less comprehensive, declare the right of the people to keep and bear arms, it has been a subject of grave discussion in some of the state courts whether a statute prohibiting persons, when not on a journey or as travelers, from wearing or carrying concealed weapons be constitutional. There has been a great difference of opinion on the question." Kent Commentaries on the American Law, 1873. Quote, "Some general knowledge of firearms is important to the public welfare, because it would be impossible, in case of war, to organize promptly an efficient force of volunteers, unless the people had some familiarity with the weapons of war. The Constitution secures the right of the people to keep and bear arms. No doubt, a citizen who keeps a gun or pistol under judicious precautions practices in safe places the use of it, and in due times teaches his sons to do the same, exercises his individual right. No doubt, a person whose residence or duties involve peculiar peril may keep a pistol for prudent self-defense." B. Abbott, Judge and Jury, A Popular Explanation of the Leading Topics in the Law of the Land, 1880. Quote, "The right to bear arms has always been the distinctive privilege of freemen. Aside from any necessity of self-protection to the person, it represents among all nations power coupled with the exercise of certain jurisdiction. It was not necessary that the right to bear arms should be granted in the Constitution, for it had always existed." J. Ordonneau, Constitutional Legislation in the United States, 1891. Part E. We now ask whether any of our precedents forecloses the conclusions we have reached about the meaning of the Second Amendment. United States v. Cruikshank, in the course of vacating the convictions of members of a white mob for depriving blacks of their right to keep and bear arms, held that the Second Amendment does not, by its own force, apply to anyone other than the federal government. The opinion explained that the right is, quote, "not a right granted by the Constitution or in any manner dependent upon that instrument for its existence. The Second Amendment means no more than that it shall not be infringed by Congress," end quote. States, we said, were free to restrict or protect the right under their police powers. The limited discussion of the Second Amendment in Cruikshank supports, if anything, the individual rights interpretation. There was no claim in Cruikshank that the victims had been deprived of their right to carry arms in a militia. Indeed, the governor had disbanded the local militia unit the year before the mob's attack. We describe the right protected by the Second Amendment as, quote, "bearing arms for a lawful purpose," end quote, and said that, quote, "the people must look for their protection against any violation by their fellow citizens of the rights it recognizes," end quote, to the state's police power. That discussion makes little sense if it is only a right to bear arms in a state militia. Presser v. Illinois, 1886, held that the right to keep and bear arms was not violated by a law that forbade, quote, "bodies of men to associate together as military organizations or to drill or parade with arms in cities and towns unless authorized by law," end quote. This does not refute the individual rights interpretation of the amendment. No one supporting that interpretation has contended that states may not ban such groups. Justice Stevens presses Presser into service to support his view that the right to bear arms is limited to service in the militia by joining Presser's brief discussion of the Second Amendment, with a later portion of the opinion making the seemingly relevant to the Second Amendment point that the plaintiff was not a member of the state militia. Unfortunately for Justice Stevens' argument, the later portion deals with the 14th Amendment. It was the 14th Amendment to which the plaintiff's non-membership in the militia was relevant. Thus, Justice Stevens' statement that Presser, quote, suggested that nothing in the Constitution protected the use of arms outside the context of a militia, end quote, is simply wrong. Presser said nothing about the Second Amendment's meaning or scope beyond the fact that it does not prevent the prohibition of private paramilitary organizations. Justice Stevens places overwhelming reliance upon this court's decision in United States v. Miller, 1939. Quote, hundreds of judges, end quote, we are told, have relied on the view of the amendment we endorsed here, end quote. And, quote, even if the textual and historical arguments on both sides of the issue were evenly balanced, respect for the well-settled views of all of our predecessors on this court and for the rule of law itself would prevent most jurists from endorsing such a dramatic upheaval in the law, end quote. And what is, according to Justice Stevens, the holding of Miller that demands such obeisance? That the Second Amendment, quote, protects the right to keep and bear arms for certain military purposes, but that it does not curtail the legislature's power to regulate the non-military use and ownership of weapons, end quote. Nothing so clearly demonstrates the weakness of Justice Stevens' case. Miller did not hold and cannot possibly read to have held that. The judgment in the case upheld against a Second Amendment challenge two men's federal convictions for transporting an unregistered short-barreled shotgun in interstate commerce in violation of the National Firearms Act. It is entirely clear that the court's basis for saying that the Second Amendment did not apply was not that the defendants were, quote, bearing arms, end quote, not for non-military purposes, but for non-military use. Rather, it was the type of weapon at issue was not eligible for Second Amendment protection. Quote, in the absence of any evidence tending to show that the possession or use of a short-barrel shotgun at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument, end quote. Quote, certainly, end quote. The court continued, quote, it is not within the judicial notice that this weapon is any part of the ordinary military equipment or that its use could contribute to the common defense. Quote. Beyond that, the opinion provided no explanation of the content of the right. This holding is not only consistent with, but positively suggests that the Second Amendment confers an individual right to keep and bear arms, though only arms that have some reasonable relationship to the preservation or efficiency of a well-regulated militia. Had the court believed that the Second Amendment protects only those serving in the militia, it would have been odd to examine the character of the weapon rather than simply note that the two crooks were not militiamen. Justice Stevens can say again and again that Miller did, quote, not turn on the difference between muskets and sawed-off shotguns. It turned rather on the basic difference between the military and non-military use and possession of guns. Quote, but the words of the opinion prove otherwise. The most Justice Stevens can plausibly claim for Miller is that it declined to decide the nature of the Second Amendment right, despite the Solicitor General's argument, made in the alternative, that the right was collective. Miller stands only for the proposition that the Second Amendment right, whatever its nature, extends only to certain types of weapons. It is particularly wrong-headed to read Miller for more than what it has said, because the case did not even purport to be a thorough examination of the Second Amendment. Justice Stevens claims that the opinion reached its conclusion, quote, after reviewing many of the same sources that are discussed at greater length by the court today, quote. Not many, which was not entirely the court's fault. The respondents made no appearance in the case, neither filing a brief nor appearing in oral argument. The court heard from no one but the government, reason enough, one would think, not to make that case the beginning and end of the court's consideration of the Second Amendment. The government's brief spent 2 pages discussing the English legal sources, concluding, quote, that at least the carrying of weapons without lawful occasion or excuse was always a crime, quote, and that because of the class-based restrictions and the prohibition on terrorizing people with dangerous or unusual weapons, quote, the early English law did not guarantee an unrestricted right to bear arms, quote. It then went on to rely primarily on the discussion of the English right to bear arms in Imet versus State, a Tennessee case, for the proposition that only the uses of arms protected by the Second Amendment are those that relate to the militia, not self-defense. The final section of the brief recognized that, quote, some courts have said that the right to bear arms includes the right of the individual to have them for protection of his person and property, quote, and launched an alternative argument that, quote, weapons which are commonly used by criminals, end quote, such as sawed-off shotguns, are not protected. The government's Miller's brief thus provided scant discussion of the history of the Second Amendment, and the court was presented with no counter-discussion. As for the text of the court's opinion itself, that discusses none of the history of the Second Amendment. It assumes that the prologue that the amendment was designed to preserve the militia, which we do not dispute, and then reviews some historical materials dealing with the nature of the militia, and in particular, with the nature of the arms their members were expected to possess. Not a word about the history of the Second Amendment. This is the mighty rock upon which the dissent rests its case. We may as well consider at this point, for we will have to consider it eventually, what types of weapons Miller permits. Read in isolation, Miller's phrase, quote, part of the ordinary military equipment, quote, could mean that only those weapons useful in warfare are protected. That would be a startling reading of the opinion, since it would mean that the National Firearm Act's restrictions on machine guns, not challenged in Miller, might be unconstitutional, machine guns being useful in warfare in 1939. We think that Miller's, quote, ordinary military equipment, quote, language must be read in tandem with what comes after. Quote, ordinarily, when called for militia service, able-bodied men were expected to appear bearing arms supplied by themselves and of the kind in common use at the time. Quote, the traditional militia was formed from a pool of men bringing arms in common use at the time and for lawful purposes like self-defense. Quote, in the colonial and Revolutionary War era, small armed weapons used by militiamen and weapons used in defense of person and home were one and the same. Quote, indeed, that is precisely the way in which the Second Amendment's operative clause furthers the purpose announced in its preface. We therefore read Miller to say only that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, such as short-barrel shotguns. That accords with the historical understanding of the right. We conclude that nothing in our precedents forecloses our adoption of the original understanding of the Second Amendment. It should be unsurprising that such a significant matter has been for so long judicially unresolved. For most of our history, the Bill of Rights was not thought applicable to the states, and the federal government did not significantly regulate the possession of firearms by law-abiding citizens. Other provisions of the Bill of Rights have similarly remained unilluminated for lengthy periods. This court first held a law to violate the First Amendment's guarantees of freedom of speech in 1931, almost 150 years after the amendment was ratified. And it was not until after World War II that we held a law invalid under the Establishment Clause. Even a question as basic as the scope of a prescribable libel was not addressed by this court until 1964, nearly 2 centuries after the founding. It is demonstrably not true that, as Justice Stevens claims, quote, for most of our history, the invalidity of the Second Amendment-based objections to firearm regulations has been well settled and uncontroversial. Quote, for most of our history, the question did not present itself. Part 3. Like most rights, the right secured by the Second Amendment is not unlimited. From Blackstone through the 19th century cases, commenters and courts routinely explained that the right was not a right to keep and carry any weapon whatsoever, in any manner whatsoever, and for whatever purpose. For example, the majority of the 19th century courts to consider the question held that prohibitions on carrying concealed weapons were lawful under the Second Amendment or state analogs. Although we do not undertake an exhaustive historical analysis today of the full scope of the Second Amendment, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. We also recognize another important limitation on the right to keep and carry arms. Miller said, as we have explained, that the sorts of weapons protected were those, quote, in common use at the time, unquote. We think that limitation is fairly supported by the historical tradition of prohibiting the carrying of, quote, dangerous and unusual weapons, quote. It may be objected that if weapons that are most useful in military service, M16 rifles and the like, may be banned, then the Second Amendment right is completely detached from the Prefatory Clause. But as we have said, the conception of the militia at the time of the Second Amendment's ratification was the body of all citizens capable of military service, who would bring the sorts of lawful weapons that they possessed at home to militia duty. It may well be true today that a militia, to be as effective as militias in the 18th century, would require sophisticated arms that are highly unusual in society at large. Indeed, it may be true that no amount of small arms could be useful against modern-day bombers and tanks. But the fact that modern developments have limited the degree of fit between the Prefatory Clause and the protected right cannot change our interpretation of the right. Part 4. We turn finally to the law at issue here. As we have said, the law totally bans handgun possession in the home. It also requires that any lawful firearm in the home be disassembled or bound by a trigger lock at all times, rendering it inoperable. As the quotations earlier in the opinion demonstrate, the inherent right of self-defense has been central to the Second Amendment right. The handgun ban amounts to prohibition of an entire class of arms that is overwhelmingly chosen by American society for that lawful purpose. The prohibition extends, moreover, to the home, where the need for self-defense, family, and property is most acute. Under any of the standards of scrutiny that we have applied to enumerated constitutional rights, banning from the home the most preferred firearm in the nation to keep and use for protection of one's home and family would fail constitutional muster. Few laws in the history of our nation have come close to the severe restriction of the district's handgun ban, and some of those few have been struck down. In Nunn v. State, the Georgia Supreme Court struck down a prohibition on carrying pistols openly, even though it upheld a prohibition on carrying concealed weapons. In Andrews v. State, the Tennessee Supreme Court likewise held that a statute that forbade openly carrying a pistol, quote, publicly or privately, without regard to time or place or circumstances, end quote, violated the state constitutional provision which the court equated with the Second Amendment. This was so even though the statutes did not restrict the carrying of long arms. Quote, a statute which, under the pretense of regulating, amounts to a destruction of the right, or which requires arms to be so borne as to render them wholly useless for the purpose of defense, would be utterly unconstitutional, end quote. State v. Reed citation, Alabama. It is no answer to say, as petitioners do, that it is permissible to ban the possession of handguns so long as the possession of other firearms, i.e. long arms, is allowed. It is enough to note, as we have observed, that the American people have considered the handgun to be the quintessential self-defense weapon. There are many reasons that a citizen may prefer a handgun for home defense. It is easier to store in a location that is readily accessible in an emergency. It cannot easily be redirected or wrestled away by an attacker. It is easier to use for those without the upper body strength to lift and aim a long gun. It can be pointed at a burglar with one hand while the other hand dials the police. Whatever the reason, handguns are the most popular weapon chosen by Americans for self-defense in the home, and a complete prohibition of their use is invalid. We must also address the district's requirement, as applied to the respondent's handgun, that firearms in the home be rendered and kept inoperable at all times. This makes it impossible for citizens to use them for the core lawful purpose of self-defense and is hence unconstitutional. The district court argues that we should interpret this element of the statute to contain an exception for self-defense. But we think that it is precluded by the unequivocal text and by the presence of certain other enumerated exceptions. Quote, except for law enforcement personnel, each registrant shall keep any firearm in his possession unloaded and disassembled or bound by a trigger lock or similar device unless such firearm is kept at his place of business or while being used for lawful recreational purposes within the District of Columbia, end quote. DC Code, Section 72507.02. The non-existence of a self-defense exception is also suggested by the D.C. Court of Appeals statement that the statute forbids residents to use firearms to stop intruders. See McIntosh v. Washington, 1978. Apart from his challenge to the handgun ban and trigger lock requirement, respondent asked the district court to enjoin petitioners from enforcing the separate licensing requirement, quote, in such a manner as to forbid the carrying of firearms within one's home or possessed land without a license, end quote. The Court of Appeals did not invalidate the licensing requirement, but held only that the district, quote, may not prevent a handgun from being moved throughout one's home, end quote. It then ordered the district court to enter a summary judgment, quote, consistent with respondent's prayer for relief, end quote. Before this court, petitioners have stated that if, quote, if the handgun ban is struck down and respondents registers a handgun, he could obtain a license, assuming he is not otherwise disqualified, end quote, by which they apparently mean if he is not a felon and is not insane. Respondent conceded at oral argument that he does not have a problem with licensing and that the district's law is permissible so long it is, quote, not enforced in an arbitrary and capricious manner, quote. We therefore assume that petitioner's issuance of a license will satisfy respondent's prayer for relief and do not address the licensing requirement. Justice Breyer has devoted most of his separate dissent to the handgun ban. He says that, even assuming the Second Amendment is a personal guarantee for the right to bear arms, the district's prohibition is valid. He first tries to establish this by founding-era historical precedent, pointing to various restrictive laws in the colonial period. These demonstrate, in his view, that the district's law, quote, imposes a burden upon gun owners that seems proportionately no greater than restrictions in existence at the time the Second Amendment was adopted, end quote. Of the laws he cites, only one offers even marginal support for his assertion. A 1783 Massachusetts law forbade the residents of Boston to take into or receive into any dwelling or house, stable, barn, outhouse, warehouse, storehouse, shop, or other building, loaded firearms, and permitted the seizure of any loaded firearms that shall be found there. That statute's text and its prologue, which makes clear that the purpose of the prohibition was to eliminate the danger to firefighters posed by the depositing of loaded arms in buildings, give reason to the doubt that colonial Boston authorities would have enforced that general prohibition against someone who temporarily loaded a firearm to confront an intruder, despite the law's application in that case. In any case, we would not stake our interpretation of the Second Amendment upon a single law, in effect, in a single city, that contradicts the overwhelming weight of other evidence regarding the right to keep and bear arms for defense of the home. The other laws Justice Breyer cites are gunpowder storage laws that he concedes did not clearly prohibit loaded weapons, but required only that excess gunpowder be kept in a special container or on the top floor of the home. Nothing about those fire safety laws undermines our analysis. They do not remotely burden the right of self-defense as much as an absolute ban on handguns. Nor, correspondingly, does our analysis suggest the invalidity of laws regulating the storage of firearms to prevent accidents. Justice Breyer points to other founding-era laws that he says, quote, restricted the firing of guns within the city limits to at least some degree, quote, in Boston, Philadelphia, and New York. Those laws provide no support for the severe restriction in the present case. The New York law levied a fine of 20 shillings on anyone who fired a gun in certain places, including houses, on New Year's Eve and the first 2 days of January, and was aimed at preventing, quote, the great damages frequently done on those days by persons going house to house with guns and other firearms and being often intoxicated with liquor, quote. It is inconceivable that this law would have been enforced against a person exercising his right to self-defense on New Year's Day against such a drunken hooligan. The Pennsylvania law to which Justice Breyer refers levied a fine of 5 shillings on one who fired a gun or set off fireworks in Philadelphia without first obtaining a license from the governor. Given Justice Wilson's explanation that the right to self-defense with arms was protected by the Pennsylvania Constitution, it is unlikely that this law, which in any event amounted to at most a licensing regime, would have been enforced against a person who used firearms for self-defense. Justice Breyer cites a Rhode Island law that simply levied a 5-shilling fine on those who fired guns in streets and taverns, a law obviously inapplicable to this case. Finally, Justice Breyer points to the Massachusetts law similar to the Pennsylvania law prohibiting, quote, discharging any gun or pistol charged with shot or ball in the town of Boston, quote. It is again implausible that this would have been enforced against a citizen acting in self-defense, particularly given its preambulatory reference to, quote, the indiscreet firing of guns, quote. A broader point about the laws that Justice Breyer cites, all of them punished the discharge or loading of guns with a small fine and forfeiture of the weapon, or in a few cases, a very brief stay in local jail, not with significant criminal penalties. They are akin to modern penalties for minor public safety infractions like speeding or jaywalking. And although such public safety laws may not contain exceptions for self-defense, it is inconceivable that the threat of a jaywalking ticket would deter someone from disregarding a "do not walk" sign in order to flee an attacker, or that the government would enforce those laws under such circumstances. Likewise, we do not think that a law imposing a 5-shilling fine and forfeiture of the gun would have prevented a person in the founding era from using a gun to protect himself or his family from violence, or that if he did so, the law would be enforced against him. The district law, by contrast, far from imposing a minor fine, threatens citizens with a year in prison, 5 years for a second violation, for even obtaining a gun in the first place. Justice Breyer moves on to make a broad jurisprudential point. He criticizes us for declining to establish a level of scrutiny for evaluating the Second Amendment restrictions. He proposes, explicitly at least, none of the traditionally expressed levels: strict scrutiny, intermediate scrutiny, and rational basis, but rather a judge-empowering interest-balancing inquiry that, quote, asks whether the statute burdens a protected interest in a way or to an extent that is out of proportion to the statute's salutary effects upon other important governmental interests, quote. After an exhaustive discussion of the arguments for and against gun control, Justice Breyer arrives at his interest-balanced answer. Because handgun violence is a problem, because the law is limited to an urban area, because there were somewhat similar restrictions in the founding period, a false proposition that we have already discussed, the interest-balancing inquiry results in the constitutionality of the handgun ban. We know of no other enumerated constitutional right whose core protection has been subjected to freestanding interest-balancing approach. The very enumeration of the right takes out of the hands of government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon. A constitutional guarantee subject to future judges' assessments of its usefulness is no constitutional guarantee at all. Constitutional rights are enshrined with the scope they were understood to have when the people adopted them. Whether or not the future legislatures, or yes, even future judges, think that scope too broad, we would not apply an interest-balancing approach to the prohibition of a peaceful neo-Nazi march through Skokie. See National Socialist Party of America versus Skokie, 1977. The First Amendment contains the freedom of speech guarantee that the people ratified, which included exceptions for obscenity, libel, and disclosure of state secrets, but not for the expression of extremely unpopular and wrong-headed views. The Second Amendment is no different. Like the first, it is the very product of an interest balancing by the people, which Justice Breyer would now conduct for them anew. And whatever else it leaves to future evaluation, it surely elevates above all other interests the right of law-abiding, responsible citizens to use arms in defense of hearth and home. Justice Breyer chides us for leaving so many applications of the right to keep and bear arms in doubt, and for not providing extensive historical justification for those regulations of the right that we described as permissible. But since this case represents this court's first in-depth examination of the Second Amendment, one should not expect it to clarify the entire field any more than Reynolds versus United States, 1879, our first in-depth free exercise clause case, left that area in a state of utter certainty. And there will be time enough to expound upon the historical justifications for the exceptions we have mentioned, if and when those exceptions come before us. In sum, we hold that the district's ban on handgun possession in the home violates the Second Amendment, as does its prohibition against rendering any lawful firearm in the home operable for the purposes of immediate self-defense. Assuming that Heller is not disqualified from the exercise of Second Amendment rights, the district must permit him to register his handgun and must issue him a license to carry it in the home. We are aware of the problem of handgun violence in this country, and we take seriously the concerns raised by the many amici who believe that prohibition of handgun ownership is a solution. The Constitution leaves the District of Columbia a variety of tools for combating that problem, including some measures regulating handguns. But the enshrinement of constitutional rights necessarily takes certain policy choices off the table. These include the absolute prohibition of handguns held and used for self-defense in the home. Undoubtedly, some think that Second Amendment is outmoded in a society where our standing army is the pride of our nation, where well-trained police forces provide personal security, and where gun violence is a serious problem. That is perhaps debatable. But what is not debatable is that it is not the role of this court to pronounce the Second Amendment extinct. We affirm the judgment of the Court of Appeals. It is so ordered. Well, my eyes take a moment to focus on anything other than something about 18 inches in front of my face after reading that case forever. Let me know what you think about this. Do you want to see more cases like this? Key, important, foundational documents put kind of voice to tape so that many of you can take advantage of this great technology called YouTube. Let me know down in the comments section below whether or not this was useful and you want to see more. Hit that like button. I hope you all take care. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.